Hi, I'm Aaron Kendall of Kendall Law Group. Today we're going to talk about probate, and most specifically, the probate of an estate with a will. That's because probate has two different types: testate, which means there is a will, or intestate, which means there is no will for the court to process. The probate process, in the case of a will, moves ahead and processes the will and appoints a personal representative to carry it out. The way that works is the will, along with a death certificate and an application for probate, is filed with the probate court. Assuming the forms are done correctly, the court will then appoint the personal representative, which is typically the person named in the will to be that personal representative. Personal representative then has the legal duty to carry out the terms of the will and also to carry out the requirements of probate under Michigan law. This will include providing a notice to creditors, doing an inventory of the estate, paying the inventory fee, distributing the assets, dealing with creditors, and then finally closing the estate. The entire process can take typically around 6 months to complete. Generally, probate with a will is for the most part straightforward, but it is again time-consuming, taking around at least 6 months or more, and if there are difficulties or issues that arise, they do have to be addressed. So, if you do have a will and it needs to be probated, it generally makes sense to have an attorney who knows how to handle the process, as that tends to save time and money, because if you don't, it typically becomes a lot more difficult in dealing with the court. If you do have any questions about the probate process with a will, feel free to reach out and contact me, or join the Michigan Estate and Asset Planning group on Facebook, or contact me at kendall-law.com, and I'd be very happy to discuss them with you and see if I can help. Thank you.